Okay. Now, this is Mental Hygiene Law, Article 929, Involuntary Admission on Medical Certification, Notice of Admissions to Patients and Others. Now, this is involuntary. The other stuff that I was talking about earlier was voluntary. Now, this is involuntary. Again, here we are, so let's go. Involuntary admissions on medical certification, notice of admissions to patients and others. The director shall cause written notice of a person's involuntary admission on an application supported by medical certification to be given forthwith to the Mental Hygiene Legal Services. B. The director shall cause written notice of the admission of such person, including such person's right under this article, to be given personally or by mail not later than 5 days. Again, the director shall cause written notice on this one. It's also 5 days, excluding Sunday and holidays, after the admission to the following. So notice 5 days, excluding Sunday and holidays, after such admission to the following. 1. The nearest relative of the person alleged to be mentally ill other than the applicant, if there be any such person known to the director, or 2, as many as 3 additional persons, if designated in writing, receiving such notice by the person so admitted. When the fuck are we ever going to use this? I don't understand. But here it is. We need to know this for some fucking reason that I don't even, there's probably one person in every county who does anything with mental hygiene of these people, and yet we need to know all this crap. Mental Hygiene Law, Article 9.31, Involuntary Admission on Medical Certification, Patient's Right to a Hearing, at any time prior to the expiration of 60 days from the date of involuntary admission. Again, at any time prior to the expiration of 60 days from the date of involuntary admission of a patient on an application supported by medical certification, he or any relative or friend or the Mental Hygiene Legal Services gives notice in writing to the director or request for a hearing on the question of need for involuntary care and treatment. A hearing shall be held as herein provided. Oh, this is actually something that makes sense for us. We do hearings at work. Okay. The patient or person requesting a hearing on behalf of the patient may designate the county where the hearing shall be held, which shall be either in the county where the hospital is located, or the county of the patient's residence, or the county in which the hospital to which the patient was first admitted is located. Okay, so that's a little different there. Okay, so the patient or the person requesting a hearing can go to one of 3 places to have this hearing to see if about this involuntary thing, which is different from the last one we did before, where the director wanted a hearing. She had to go to, or in order, she or he, whatever, had to go to the Supreme or County Court where the hospital was located. Here, the person or patient requesting a hearing on behalf of the patient may designate the county. This is venue now. For this hearing, the patient, what is this hearing for now? Okay, it just says right to a hearing. I don't even know what it's for. Okay. For a hearing on the question of need for involuntary care and treatment, a hearing shall be held as herein provided. The patient or person requesting a hearing on behalf of the patient may designate 1, the county where the hearing... No. Okay, forget it. The patient or person requesting a hearing on behalf of the patient may designate the county where the hearing shall be held, which shall be either 1, in the county where the hospital is located, 2, the county of the patient's residence, or 3, the county in which the hospital to which the patient was first admitted is located. Such hearing shall be held in the county so designated, subject to application by any interested party, including the director, for a change of venue to any other county because of the convenience of parties or witness or the condition of the patient, upon notice to the person required to be served with notice of the patient's initial admission. God. B. It shall be the duty of the director, upon receiving notice of such request for hearing, to forward forthwith a copy of such notice with a record of the patient to where the Supreme Court or the county court in the county designated by the applicant, if one be designated, or if no designation be made, then to the Supreme Court or the county court in the county where such hospital is located. A copy of such notice and record shall also be given to the Mental Hygiene Legal Service. C. The court which receives such notice shall fix the date of such hearing at a time not later than 5 days from the date such notice is received by the court, and cause the patient and other person requesting the hearing, the director, the Mental Hygiene Legal Service, and such other person as the court may determine to be advised of such date. So in this article so far, we have a 60 days rules, we have 5-day rules, and I think there was 10 days somewhere. There was 10 days somewhere in here in the beginning. I think that's it. I'm not sure. Ugh, I'm going to have to go through this again. Okay. Where am I? Okay. So now what does the court do? Upon such date, the court shall hear testimony and examine the person alleged to be mentally ill, if it is deemed advisable in or out of court. If it be determined that the patient, is in need of retention, the court shall deny the application for the patient's release. Where did we get to release? Okay, I don't know. If the patient is in a psychiatric hospital maintained by a political division of the state or in a general hospital, the court, upon notice to the patient and the Mental Hygiene Legal Service and an opportunity to be heard, may order the patient transferred to the jurisdiction of the Department for Retention in a hospital operated by the state, designated by the commissioner, or to a private facility having an appropriate operating certificate for retention therein for the balance of the period for which the hospital is authorized to retain the patient. I mean, this is like really too much. Okay, let's see what else happens. Okay. Article 9, 9.33, court authorization to retain an involuntary patient. God, we're finally like getting to stuff that the court actually does. Okay. If the director shall determine that a patient admitted upon an application supported by medical certification for whom there is no court order authorizing retention for a specified period is in need of retention, and if such patient does not agree to remain in such hospital as a voluntary patient, the director shall apply to the Supreme Court or the county court in the county where the hospital is located for an order authorizing continued retention. Such application shall be made no later than 60 days from the date of involuntary admission on application supported by medical certification, or 30 days from the date of an order denying an application. Okay, so it's 60 days from the date of involuntary admission, or 30 days on an order denying an application for the patient's release, whichever is later. And the hospital is authorized to retain the patient for such further period during which the hospital is authorized to make such application or during which the application may be pending. The director shall cause written notice of such application to be given to the patient, and a copy shall be given personally or by mail to the persons required by this article to be served with notice of such patient's initial admission and to the mental hygiene legal service. Such notice shall state that a hearing may be requested and that failure to make such a request within 5 days, excluding Sunday and holidays, from the date that the notice was given to the patient will permit the entry without a hearing of an order authorizing retention. If no request is made for a hearing on behalf of the patient within 5 days, excluding Sunday and holidays, from the date such notice, this is like so repetitive, so we keep hearing the same thing, of such application was given such patient, and if the mental hygiene legal service has not requested a hearing, the court receiving the application may, if satisfied that the patient requires continued retention for care and treatment or transfer and continued retention, immediately issue an order authorizing continued retention of such patient in such hospital for a period not to exceed 6 months from the date of the order. Continued retention of such patient in such hospital for a period not to exceed 6 months from the date of the order. Or, if such patient is in a psychiatric hospital operated by a political subdivision of the state or in a general hospital, such order may direct the transfer of such patient to the jurisdiction of the department for retention in a hospital operated by the state, blah, 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 or to a private facility having an appropriate operating certificate to be retained herein for a period not to exceed 6 months. Is that 6 months on the other one? Yeah, 6 months. Okay. Retained 6 months, not to exceed 6 months from the date of such order. Upon the demand of the patient or of anyone on his behalf or upon request of the mental hygiene legal service, the court shall or may, on its own motion, fix a date for the hearing of the application and like answer, blah, blah, blah. The provisions of such section shall apply to the procedure for obtaining and holding a hearing and to the granting or refusal to grant an order of retention by the courts. Except if they've already had a hearing, he shall not have the right to designate initially the county in which the hearing shall be held. If the director of a hospital in which a patient is retained shall determine that the condition of such patient requires his further retention in a hospital, he shall, if such patient does not agree to remain in such hospital as a voluntary patient, apply during the period of retention authorized by the last order of the court to the Supreme Court or the county court in the county where the hospital is located for an order authorizing further continued retention of such patient. The procedures for obtaining an order shall be in accordance with the provision of the foregoing section, blah, 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 provided that the patient or anyone on his behalf or the mental hygiene legal services may request that the patient be personally before the court, in which case the court shall not grant an order for periods of 1 year or longer unless such patient shall have appeared personally before the court. The period for continued retention pursuant to the first order shall authorize further continued retention of the patient for not more than 1 year from the date of the order. The period for the further continued retention of the patient authorized by any subsequent order shall be for periods not to exceed 2 years each from the date of the order. This is making me want to fucking become mentally ill. Oh my god. Alright, rant over. Back to reality. 935, review of court authorization to retain an involuntary patient. If a person who has been denied release or whose continued retention or transfer and continued retention has been authorized pursuant to this article, or any relative or friend in his behalf, be dissatisfied with any such order, he may, within 30 days after the making of any such order, obtain a rehearing and a review of the proceedings already had and of such order upon a petition to a justice of the Supreme Court other than the judge or justice presiding over the court making such order. What? They can have another hearing from another judge. Okay. Whatever. Such justice shall cause a jury to be summoned and shall try the question of the mental illness and the need for retention of the patient so authorized to be retained. Any such patient or the person applying on his behalf for such review may waive the trial of the fact by a jury and consent in writing to trial of such fact by the court. No such petition for rehearing and review shall be made by anyone other than the person so authorized to be retained, or the father, mother, husband, wife, or child of such person, unless the petitioner shall have first obtained the leave of the court upon good cause shown. If the verdict of the jury, now it doesn't even say what the jury is, how many people are on the jury, there's nothing here. It just says the jury. So I don't know how many people are on this jury. Do we even care? Who cares? Okay. If the verdict of the jury or the decision of the court when the jury trial has been waived be that such person is not mentally ill or is not in need of retention, the justice shall forthwith discharge him. But if the verdict of the jury or the decision of the court where a jury trial has been waived, whatever, a jury trial or a bench trial, be that such person is mentally ill and in need of retention, the justice shall certify that fact and make an order authorizing continued retention under the original order. Such order shall be presented at the time of authorization of continued retention of such mentally ill person to and filed with the director of the hospital in which the mentally ill person is authorized to be retained, and a copy shall be forwarded to the department by such director and filed in the office thereof. Okay, so this order only needs to be one copy filed with the director of the hospital and shall be forwarded to the department by such director and filed in the office. Okay. Proceedings under the order shall not be stayed pending an appeal. Proceedings under the order shall not be stayed pending an appeal except upon an order of a justice of the Supreme Court made upon a notice and after a hearing with provisions made therein for such temporary care or confinement of the alleged mentally ill person as may be deemed necessary. Okay. Mental Hygiene Law 937, involuntary admission on certificate of a director of a community services or his designee. So now we have these other people coming into play here. The director of a hospital, upon application by a director of community services or an examining physician duly designated by him or her, may receive and care for in such hospital as a patient any person who, in the opinion of the director of community services or the director's designee, has a mental illness for which immediate inpatient care and treatment in a hospital is appropriate and which is likely to result in serious harm to himself or herself or others. The need for immediate hospitalization shall be confirmed by a staff physician of the hospital prior to admission. When are they doing this? Within 72 hours. Now, this one is excluding Sunday and holidays after such admissions if such patient is to be retained for care and treatment beyond such time and he or she does not agree to remain in such hospital as a voluntary patient. The certificate of another examining physician who is a member of the psychiatric staff of the hospital that the patient is in need of involuntary care and treatment shall be filed with the hospital. Why is every sentence like 5 sentences in one? Where am I? Okay, from the time of his or her admission under this section, the retention of such patient for care and treatment shall be subject to the provisions for notice, hearing, review, and judicial approval of continued retention or transfer, and continued retention provided by this article for the admission and retention of involuntary patients, provided that, for the purpose of such provisions, the date of admission of the patient shall be deemed to be the date when the patient was first received in the hospital. Really? Oh, God. Now let's see what else we got in here. That was A, right? Okay, B. Oops. Oh, I thought it wasn't recording. Yeah, okay. B. The application for admission of a patient pursuant to this section shall be based upon a personal examination by a director. It shall be in writing. Okay. The application for admission shall be based upon personal examination by a director of community service or his designee. Shall be in writing and shall be filed with the director of the hospital at the time of the patient's reception, together with a statement in a form prescribed by the commissioner giving such information as he may deem appropriate. What? I don't know about this stuff. There's just way too much. Okay. If the patient is admitted, the need for hospitalization shall be confirmed by another staff physician within 24 hours. An application pursuant to this subdivision shall be in writing and shall be filed with the director of such hospital at the time of the patient's reception, together with a statement in a form prescribed by the commissioner giving such information as he may deem appropriate, including a statement of the efforts made by the director of community service to locate a designated examining physician prior to making an application. After signing the application, the director of community service or the director's designee shall be authorized and empowered to take into custody, detain, transport, and provide temporary care for any such person upon the written request of such director or the director's designee. It shall be the duty of peace officers or police officers who are members of the state police. Oh, so state police. Oh, or of the sheriff. Oh, state police or the sheriff or peace officer working as a special designee, whatever. Upon the written request of such director, Upon the written request of such director or the director's designee, it shall be the duty of peace officer, a police officer, as a state police or a sheriff department to take into custody and transport any such person requested and directed by such director or designee. Upon the written request of such director or designee, an ambulance service as defined in subdivision 2, section 3001 of the Public Health Law is authorized to transport any such person. I can't. Oh my gosh. Reasonable expenses incurred by the director of community mental hygiene services or his designee for the examination of temporary care. I mean, do we really need to know this? I don't know. Oh my god. Oh my god. All right, let me just do it. Reasonable expenses incurred by the Director of Community Mental Hygiene Services or his designee for the examination and... Okay, this is Mental Hygiene Law Article 940. This is the other thing that's always stated. It's 939 and 940 are stated like in the beginning that I read. So, okay. Emergency observation. Oh, and this for some reason is going to be taken out because I was looking to see that they're changing. It's going to be amended or repealed or something. Where does it say? Oh yeah, this is going to be repealed in July 1st of 2020. This whole thing, so it's going to be out of everything else. So I'm going to do it, but it's going to be repealed. Okay. Emergency observation, care, and treatment and comprehensive psychiatric emergency program. The director of any comprehensive psychiatric emergency program may receive and retain therein for a period not to exceed 72 hours any person alleged to have a mental illness for which immediate observation, care, and treatment in such program is appropriate, and which is likely to result in serious harm to the person or others. The director shall cause to be entered upon the program records, the name of the person or persons, if any, who have brought the person alleged to have a mental illness to the program, and the details of the circumstances leading the person or person to bring the person alleged to have a mental illness to the program. Okay. The director shall cause examination of such persons to be initiated by a staff physician as soon as practicable, and in any event within 6 hours. That is very different. Okay. Examination must be done as soon as practicable within 6 hours after the person is received into the program's emergency room. The person may be retained for observation, care, and treatment and further examination for up to 24 hours if at the conclusion of such examination, such physician determines that the person may have a mental illness for which immediate observation, care, and treatment in a comprehensive psychiatric emergency program is appropriate, and which is likely to result in serious harm to the person or others. No person shall be involuntarily retained with this section for more than 24 hours. So it can be involuntarily retained, but not more than 24 hours. Within that time, the examination by another physician who's a member of the psychiatric staff of the program, and a person is admitted to an extended observation bed. Really? Come on. Okay, the person shall be served with a written notice of his status and rights as a patient. The notice shall contain the patient's name. The notice shall be provided to the same person, and in the same manner as the section before, section 939, with written request. Written requests for court hearings on the question of need for immediate observation, care, and treatment shall be made, and court hearings shall be scheduled and held in the manner provided in 939. However, if a person is removed or admitted to a hospital pursuant to E or F of this section, the director shall be substituted for the director of the comprehensive psychiatric emergency program. The director of the hospital shall be substituted for the director of the psychiatric emergency program in all legal proceedings regarding the continued retention of that person. Okay. If at any time it's determined that the person is no longer in need of immediate observation, care, and treatment, and is not in need of involuntary care in the hospital, such person shall be released without regard, unless such person agrees to be admitted to another appropriate hospital as a voluntary or informal patient. If at any time within the 72-hour period it's determined that the person continues to require immediate observation, care, and treatment, is likely to continue beyond the 72-hour period, such person shall be removed within a reasonable period of time to an appropriate hospital, and such person shall be evaluated for admission, and if appropriate shall be admitted to such hospital, except that if the person is admitted, the 15-day retention period of subdivision B of 939 of this article shall be calculated from the time such person was initially registered into the emergency room of the psychiatric emergency program. Okay. Any person removed to a hospital without regard of this chapter and shall not be considered to have been transferred or discharged to another hospital. F. Nothing in this section shall preclude the involuntary admission of a person to an appropriate hospital pursuant to the provisions of this article, if at any time during the 72-hour period it is determined that the person is in need of involuntary care and treatment in a hospital, and the person does not agree to be admitted to a hospital as a voluntary or informal patient. Okay, if a person is examined and determined to be mentally ill, the fact that such person suffers from alcohol or substance abuse shall not preclude receipt or retention under this article, under this section. This seems to be a recurring thing. So maybe that's good to just remember. If a person is examined and determined to be mentally ill, the fact that the person suffers from alcohol or substance abuse shall not preclude the receipt or retention under this article. Sorry. And all time periods referenced in this section shall be calculated from the time such person is initially registered into the emergency room of the Comprehensive Psychiatric Emergency Program.